Judge Andrew H. Stone thought he had Congresswoman Jasmine Crockett exactly where he wanted her. The 73-year-old federal judge appointed during the Trump administration had just asked a question that was supposed to end her legal career before it even started. But what happened next left every legal expert in that Dallas courtroom completely speechless. Stone leaned back in his chair with that smug smile he was famous for. The same expression he wore when he dismissed civil rights cases and ruled against voting rights activists. He thought this young black woman from Texas would crumble under pressure. He was dead wrong. What Crockett said next didn't just silence the courtroom. It sent shock waves through the entire legal community and proved why this Harvard-educated lawyer-turned-congresswoman is someone you never want to underestimate. Before we dive into this incredible showdown, hit that like button and subscribe so you never miss these jaw-dropping political moments. Trust me, you're going to want to see how this ends. And make sure to ring that notification bell because stories like this prove why we need to stay informed about what's really happening in our courts. The federal courthouse in Dallas buzzed with tension that Tuesday morning. News cameras lined the steps outside. Reporters whispering about what many expected to be a routine hearing. Local news stations had sent their junior reporters thinking this would be a quick, boring, procedural story about voting rights paperwork. They had no idea they were about to witness one of the most explosive courtroom confrontations in recent legal history. The kind of moment that gets replayed in law schools and shared millions of times across social media. The kind of showdown that reminds America why some fights are worth having, no matter how powerful your opponent thinks they are. But nothing about Jasmine Crockett is routine. And Judge Stone was about to learn that the hard way. To understand why this confrontation mattered so much, you need to know who was really sitting in that courtroom that day. At 42, Jasmine Crockett represents everything that terrifies the old guard. She's a Harvard law graduate who built her reputation defending the powerless against the powerful before becoming a congresswoman representing Texas's 30th district. She spent years as a civil rights attorney, taking on cases that others wouldn't touch. Crockett grew up in St. Louis, raised by a single mother who worked 2 jobs to keep the lights on. She knows what it's like to fight for everything you get. Her path to Congress wasn't handed to her. She earned every step through late nights in law libraries and courtrooms where she was often the only black woman in the room. But here's what makes her dangerous to people like Judge Stone. She's not intimidated by titles, robes, or reputation. She's faced down hostile judges before, and she's never backed down from a fight when justice is on the line. In fact, her colleagues in Congress often joke that Crockett doesn't just enter a room, she owns it. During her time as a civil rights attorney, Crockett had developed a reputation for being completely fearless in court. Other lawyers would warn her about difficult judges, hostile opposing counsel, or impossible cases. Her response was always the same. I didn't come this far back down now. She'd built her legal career on taking cases that scared other attorneys. The voting rights violations that seemed too complex to prove. The discrimination cases that powerful defendants thought they could bury with expensive lawyers and endless motions. The civil rights violations that happened in small towns where everyone knew everyone and speaking up meant risking everything. But Crockett thrived in those impossible situations. She had a gift for finding the one legal argument that opponents hadn't considered, the one precedent that changed everything, the one constitutional principle that made their defense crumble. Judge Stone represents the old system that Crockett has spent her career challenging. Appointed by Trump in 2019, Stone built his reputation as a prosecutor who never met a civil rights case he couldn't dismiss. At 73, he's been on the bench long enough to think his word is law and his authority unquestionable. Stone comes from old Dallas money. His grandfather was a federal judge. His father was a federal judge. And he's always believed the bench was his birthright. He's known for his sharp tongue and his habit of putting uppy lawyers in their place, especially young attorneys who dare to challenge his rulings. Stone's approach to civil rights cases had earned him a reputation that struck fear into the hearts of young attorneys. He would start by questioning their qualifications, then move to attacking their motives and finally dismiss their arguments as activist rhetoric rather than serious legal work. The legal community had whispered stories about Stone for years. There was a young Latina attorney who left his courtroom in tears after he suggested she learn English before trying practice law. The black male attorney who Stone had threatened with contempt for raising his voice when he spoke at normal volume. The female attorney who Stone had lectured about knowing her place when she objected to his ruling. But the stories weren't just about individual attorneys. Stone had a pattern of dismissing civil rights cases before hearing full arguments. He would find procedural reasons to throw out voting rights lawsuits. He would rule that discrimination victims hadn't proven their cases before allowing them to present evidence. He would lecture attorneys about wasting the court's time with political cases. The legal community knows Stone's reputation. He's a judge who dismissed 3 separate voting rights cases in Texas. He's the one who ruled that police officers couldn't be held liable for excessive force in a case that made national headlines. He's never been afraid to use his gavel as a weapon against lawyers he doesn't respect. This wasn't just any routine court appearance. Crockett was there representing constituents in a voting rights case that could affect millions of Texans. Stone had already signaled his hostility to the case, making comment from a bench that legal experts called deeply troubling. But the real stakes were bigger than this one case. This was about whether young, progressive lawyers like Crockett could get fair hearings in federal court. It was about whether judges like Stone could continue intimidating attorneys who fight for civil rights. The legal community was watching. If Stone could humiliate Crockett in open court, it would send a message to every other young attorney. Stay in your lane. Respect your elders and don't challenge the system. Stone thought he held all the cards. He had the robe, the gavel, and 40 years of experience crushing lawyers who got too big for their britches. What he didn't count on was facing someone who had been fighting bullies her entire life. The courtroom fell silent as Judge Stone called the hearing to order. His voice carried that familiar edge that veteran court reporters recognized. This wasn't going to be a friendly proceeding. Counselor Crockett, Stone began, emphasizing her title with obvious disdain. I've reviewed your motion, and I have to say I'm concerned about the legal reasoning presented to this court. Crockett stood at the podium, her navy blue suit crisp, her posture confident. Your Honor, I'm happy to address any concerns the court may have about our civil rights claim. Stone's eyes narrowed. Here was his first opening. Civil rights claim, Miss Crockett. Are you aware that this court has a long history of dealing with frivolous civil rights lawsuits? The temperature in the room seemed to drop. Veteran attorneys in the gallery exchanged glances. Stone was already showing his hand, dismissing the case before hearing the arguments. Your Honor, Crockett replied smoothly. Every case deserves to be heard on its merits, regardless of the court's previous decisions. Stone's jaw tightened. This young woman wasn't backing down like he expected. Let me ask you something, Counselor, Stone continued, his voice getting sharper. How many voting rights cases have you actually tried before federal court? It was a classic intimidation tactic. Stone was trying to establish that Crockett was out of her league, too inexperienced to be in his courtroom. Your Honor, I've litigated dozens of civil rights cases, including several voting rights matters at the state level. Crockett responded calmly. State level, Stone repeated, letting the words hang in the air like an insult. This is federal court, Miss Crockett. We operate under different standards here. Standards that require substantial experience. The courtroom was dead quiet. Even the court reporter looked uncomfortable as Stone's hostility became impossible to ignore. But Crockett didn't flinch. Your Honor, I'm confident in my ability to represent my clients effectively before this court. Stone leaned forward, thinking he had her cornered. Let me ask you about your clients then. These voters you claim have been disenfranchised. Have you personally verified their registration status? Have you confirmed they were prevented from voting by the state's requirements? It was a loaded question designed to make Crockett look unprepared. She said yes, Stone would demand proof. If she said no, he'd accuse her of bringing frivolous claims. Your Honor, we have extensive documentation supporting each of our clients' claims, Crockett replied. Documentation, Stone repeated mockingly. That's not what I asked. I asked if you personally verified these claims, or are you just taking their word for it? The implication was clear. Stone was suggesting Crockett was either incompetent or lying. By now, everyone in the courtroom could see what was happening. This wasn't a legal proceeding. It was a public humiliation attempt. Stone was trying to destroy Crockett's credibility in front of the legal community. Several attorneys in the gallery looked uncomfortable. A few whispered each other about Stone's obvious bias, but no one spoke up in Judge Stone's courtroom. You stayed quiet and hoped you weren't next. Furthermore, Stone continued, his voice rising. I'm troubled by some of the language in your brief. You make several references to systemic discrimination and historical disenfranchisement. Are you suggesting this court has been complicit in discrimination? Now Stone was trying to make this personal. He was baiting Crockett into saying something that would give him grounds to hold her in contempt. Crockett paused for just a moment. Everyone in the room held their breath. Would she back down? Would she apologize and retreat like so many young attorneys before her? Ms. Crockett, Stone said, his voice dripping with condescension. Let me make something very clear. In my courtroom we deal with facts and law, not political narratives. If you can't distinguish between legal advocacy and activist rhetoric, perhaps you should reconsider whether federal practice is right for you. Stone paused dramatically, letting his words sink in. He looked around the courtroom as if addressing the entire legal community. I've been on this bench for over a decade, and I've seen too many young attorneys who think passion can substitute for preparation, who believe volume can replace legal reasoning. His voice grew even more condescending. Miss Crockett, representing Congress doesn't make you a constitutional scholar. Being young doesn't make you progressive. And being loud certainly doesn't make you right. That was it. Stone had crossed every possible line. He wasn't just attacking her legal arguments anymore. He was attacking her personally, professionally, and politically. He was essentially telling a sitting congresswoman and Harvard-educated attorney that she didn't belong in federal court, that her age disqualified her, that her passion invalidated her expertise. The silence in the courtroom was deafening. Court staff looked at their desks. Attorneys stared at their hands. Everyone was waiting to see if Crockett would crumble under the pressure. But as Stone sat back in his chair with that smug smile, thinking it just ended Jasmine Crockett's legal career, he had no idea that he had just awakened something powerful. Crockett looked up at the bench, her eyes steady, her voice clear. What she said next would be quoted in law schools for decades to come. Jasmine Crockett took one step closer to the podium, her voice clear and unwavering as she looked directly at Judge Stone. Your Honor, with all due respect, I need to address what's happening in this courtroom today. Stone's eyebrows shot up. No one had ever started a response to him like that. You've questioned my experience, my competence, and my right to practice before this court. You suggested that my client's claims are frivolous without hearing our evidence. You've implied that I'm bringing political rhetoric rather than legal arguments. The courtroom was frozen. Every person present realized they were witnessing something extraordinary. Your Honor, I am a graduate of Harvard Law School. I am a licensed attorney in good standing. I am an elected member of the United States Congress. But more importantly, I am here representing American citizens whose constitutional rights have been violated. Stone's face was turning red. He wasn't used to being challenged so directly. Crockett continued, her voice getting stronger with each word. You asked about my experience with voting rights cases. Let me tell you about my experience. I've represented voters who waited 8 hours in line because polling locations in their communities were mysteriously reduced. I've fought for elderly voters who were denied assistance because of language barriers. I've stood up for students whose campus polling locations disappeared the week before elections. She paused, letting that sink in. Your Honor, you mentioned that this court operates under different standards. You're absolutely right. This court operates under the Constitution of the United States, which guarantees every American citizen a right to vote regardless of their zip code, their income, or the color of their skin. Stone tried to interrupt. Miss Crockett, I don't need a civics lesson. Actually, Your Honor, I think you do. The gasps in the courtroom were audible. No one talked to Judge Stone like that. Crockett pulled out a folder from her briefcase. Because if this court truly operated under constitutional standards, you would know that the Supreme Court in Shelby County versus Holder didn't eliminate the need for voting rights protection. It actually made cases like ours more important, not less. She opened the folder and began reading. In Anderson versus Celebers, the Supreme Court held that voting is a fundamental right that cannot be infringed without compelling justification. In Burdick versus Taxure, the court established that any law restricting voting rights must be narrowly tailored to serve a compelling state interest. Stone's mouth was hanging open. This wasn't going according to his script. In Harper versus Virginia Board of Elections, the court ruled that wealth cannot be a barrier to voting. In Dunn versus Blumstein, the court struck down unnecessary residency requirements. Should I continue, Your Honor? Crockett was just getting started. You suggested that I haven't verified my client's claims personally. Let me tell you what I verified. I verified that Mrs. Rodriguez, a 67-year-old grandmother, was turned away from voting because her address didn't match her ID exactly, even though she's lived in the same house for 30 years. She flipped to another page. I verified that Mr. Johnson, a college student, was denied the right to vote because the polling location on his campus was closed without notice, forcing him to travel 40 m to the nearest location on a day he was working 2 jobs to pay for school. I verified that Miss Washington, a single mother 3, couldn't vote because she couldn't afford to take time off work to wait in a 4-hour line caused by reduced polling stations in her district. The courtroom was completely silent except for Crockett's voice. Your Honor, you asked if I personally verified these claims. I've done more than verify them. I've lived them. I grew up in communities where voting was a privilege you had to fight for, not a right that was protected. Crockett looked directly at Stone, her voice unwavering. You mentioned that I should distinguish between legal advocacy and activist rhetoric. Your Honor, there is no distinction when the law itself demands justice. When the Constitution itself requires equal protection under law. She pulled out another document. The Federal Judicial Code of Conduct requires judges to avoid even the appearance of bias. Canon 2 states that judges should respect and comply with the law and should act at all times in a manner that promotes public confidence in the integrity of the judiciary. Stone's face went pale. She was quoting judicial ethics rules to him. Canon 3 requires judges to perform their duties fairly and impartially. Your Honor, questioning my right of practice before this court based on my age, my background, or your personal opinions about civil rights cases violates these fundamental principles. Furthermore, Your Honor, you asked if I was suggesting this court has been complicit in discrimination. I'm not suggesting anything. I'm stating a legal fact. Any court that dismisses civil rights claims without hearing the evidence, that questions attorneys' qualifications based on personal bias, that creates barriers to constitutional protections, that court is not upholding its constitutional duty. The silence in the courtroom was deafening. Your Honor, I took an oath as an attorney to uphold the Constitution. I took another oath as a member of Congress to protect and defend the Constitution. Today I'm keeping both of those oaths by standing here and demanding that this court do the same. Crockett closed her folder and looked directly at Stone. You suggested that perhaps federal practice isn't right for me. Your Honor, I would suggest that perhaps it's time for this court to remember that justice isn't about protecting the comfort of judges. It's about protecting the rights of citizens. She paused for effect. My clients didn't send me here to be polite to power. They sent me here to speak truth to power. And the truth is simple. Every American deserves a right to vote. And every court in America has the duty to protect that right. Judge Stone sat there, his mouth slightly open. His usual commanding presence completely deflated. For 40 years, no one had ever challenged him like this. No one had ever quoted judicial ethics rules to his face. No one had ever turned his own intimidation tactics against him. He gripped his gavel, but for the first time in decades, He didn't know what to do with it. "Your Honor," Crockett concluded, "I'm ready to present our evidence whenever the court is ready to hear it. Because that's what federal courts do. They hear evidence, they apply the law, and they protect constitutional rights. Everything else is just personal opinion." The courtroom remained silent as Stone struggled to regain his composure, but everyone present knew they had just witnessed something historic. The moment a young black woman from Texas had just given one of the most powerful federal judges in the state a constitutional law lesson he would never forget. For 30 seconds that felt like an hour, Judge Stone said nothing. His face cycled through emotions, anger, embarrassment, and something that looked suspiciously like respect. Finally, he cleared his throat. "The court will hear your evidence, Counselor Crockett." That was it. No apology for his earlier hostility. No acknowledgement of his inappropriate behavior. But everyone in that courtroom knew what had just happened. Jasmine Crockett had just forced one of the most arrogant judges in Texas to back down. As Crockett began presenting her case, something remarkable happened. Stone actually listened for the first time in the entire hearing. He took notes. He asked legitimate legal questions instead of personal attacks. The transformation was so obvious that veteran court reporters would later say they'd never seen anything like it. Within hours of the hearing's conclusion, the legal community was buzzing with news of what had happened in Stone's courtroom. Sarah Martinez, a civil rights attorney who had practiced before Stone for 15 years, couldn't believe what she was hearing. "I've seen Stone destroy careers in that courtroom," she told colleagues at the Dallas Bar Association. "I've never seen anyone not just survive his attacks, but turn them around on him like that." Professor David Kim at SMU Law School was teaching constitutional law when news of a hearing reached him. "Class," he announced, "we're changing today's lesson plan. We need to talk about what happened in federal court this morning because it's going to be studied in law schools for decades." Within 6 hours, legal blogs were posting transcripts of Crockett's response. The hashtag Crockett versus Stone was trending on legal Twitter, with attorneys sharing their own stories of judicial bullying and praising Crockett for standing up to it. Not everyone in the legal establishment was celebrating. Judge William Hayes, a longtime colleague of Stone's, defended his friend at a judicial conference that evening. Andrew Stone is a respected jurist with 40 years of experience. He should have to tolerate disrespect from lawyers who confuse activism with legal argument, but other judges weren't so supportive. Judge Patricia Williams, one of the few black federal judges in Texas, made a rare public statement. "Every attorney deserves to be heard based on their legal arguments, not questioned about their qualifications based on personal bias. The Constitution doesn't have an age requirement for civil rights advocacy." Judge Maria Santos, who presides over the Southern District of Texas, was even more direct in her criticism. At a judicial ethics seminar the following week, she spoke about the importance of maintaining courtroom dignity. "When judges allow personal bias to influence their treatment of attorneys, we undermine the entire justice system," she said, though she never mentioned Stone by name. The Federal Judicial Center, which trains federal judges, quietly announced that they would be expanding their bias training programs. While they didn't cite the Stone-Crockett confrontation specifically, legal insiders understood the connection. Most significantly, the Administrative Office of the U.S. Courts issued a rare reminder to all federal judges about maintaining civility and respect in their courtrooms. The memo emphasized that all attorneys appearing before federal courts deserve to be treated with dignity regardless of their age, background, or the nature of their cases. The Judicial Conference of the United States received 3 formal complaints about Stone's conduct within 48 hours of the hearing. While judicial complaints rarely lead to consequences, the fact that members of the bar were willing to formally challenge a federal judge showed how deeply Crockett's stand had resonated. By the next morning, video clips of Crockett's response were all over social media. MSNBC legal analyst Joyce Vance called it one of the most powerful defenses of civil rights advocacy I've ever heard in federal court. CNN's legal team analyzed a confrontation with Jeffrey Toobin, noting Crockett didn't just defend herself. She gave a masterclass in constitutional law while calling out judicial bias. It was extraordinary legal advocacy. Even Fox News legal commentator Jonathan Turley, no fan of progressive politics, had to admit Crockett's legal arguments were sound. She cited relevant case law. She understood judicial ethics, and she made her point without crossing a line into contempt. Like her or not, she knows her law. The Washington Post ran a feature story titled "The Congresswoman Who Schooled a Federal Judge," detailing Stone's history of hostile behavior towards civil rights attorneys in Crockett's unprecedented response. Back in Washington, Crockett's congressional colleagues took notice. Representative Alexandria Ocasio-Cortez tweeted, "This is what it looks like when you send people to Congress who actually understand a law and aren't afraid to use it." Republican colleagues were more cautious. But privately, several admitted they were impressed. "I disagree with her politics," one GOP member told Politico on Background. "But you have to respect someone who stands up to bullying like that." House Speaker Mike Johnson, when asked about the incident at a press conference, gave a careful response. "I believe all members of Congress should conduct themselves with dignity, whether in Congress or in courtrooms across America." But the real political impact was in Texas. Crockett's approval ratings in her district shot up by 12 points in a week. Fundraising emails highlighting her courtroom confrontation raised over $400,000 in small dollar donations. Law professors across the country began incorporating Crockett's response into their curricula. Professor Angela Davis at Harvard Law School, where Crockett had studied, assigned her students to analyze the constitutional arguments Crockett had made. What Representative Crockett did was demonstrate how constitutional advocacy should work. Professor Davis explained to her class. She didn't just cite case law. She explained why these cases matter for real people facing real barriers to voting. The Yale Law Journal requested permission to publish the full transcript of Crockett's response in their next issue on advocacy and judicial accountability. Perhaps most importantly, Crockett's stand had immediate effects on other civil rights cases. Attorney Maria Gonzalez, representing farm workers in an employment discrimination case, reported that when she appeared before a notoriously hostile judge in Houston, she referenced Crockett's argument about judicial ethics. "The judge actually paused and asked me to explain my constitutional arguments." Gonzalez said it was like he was afraid of being the next Judge Stone. The NAACP Legal Defense Fund issued a statement praising Crockett's advocacy. Representative Crockett demonstrated what we've always known, that constitutional rights don't depend on judicial approval, they demand judicial protection. For Crockett herself, the moment represented something deeper than legal victory. In an interview with Essence magazine, she reflected on what the confrontation meant. "I kept thinking about my mother working those two jobs, never giving up even when people told her she didn't belong," Crockett said. "I thought about every young lawyer who's been told to stay quiet, to respect authority even when authority is wrong. Sometimes you have to speak truth to power, even when power is wearing a black robe." 3 weeks after the confrontation, Judge Stone issued his ruling in Crockett's voting rights case. In a shocking development, he ruled in favor of clients on every major point. The ruling was notable not just for its outcome, but for his language, Stone wrote. "The court finds that the evidence presented demonstrates clear violations of constitutional voting rights. The remedies requested by plaintiffs are necessary to ensure equal protection under law." Legal experts noted that the ruling read like it was written by a different judge. Some speculated that Crockett's constitutional argument had genuinely changed Stone's perspective on civil rights law. 6 months later, the impact of that Tuesday morning in Dallas was still being felt throughout the federal court system. Young attorneys reported feeling more confident about challenging inappropriate judicial behavior. Several judges had quietly changed their approach to civil rights cases, but questions remained. Would Stone's transformation be permanent? Would other judges learn from his example? Most importantly, would Crockett's stand inspire a new generation of civil rights advocates to speak truth to power? As Crockett herself put in a speech to the Congressional Black Caucus, democracy isn't a spectator sport. Constitutional rights aren't suggestions. And justice isn't something you ask permission for. It's something you demand, whether you're in Congress or a courtroom or a polling place. The story of Jasmine Crockett versus Judge Andrew Stone became more than just a legal confrontation. It became a reminder that, in America, the Constitution belongs to everyone, and sometimes it takes someone willing to fight for it to make that truth real. Today, law students study Crockett's response as an example of effective constitutional advocacy. Judicial ethics seminars use the confrontation as a case study in bias and fairness. And across America, young attorneys facing hostile judges remember that Tuesday in Dallas when one woman stood up, spoke truth to power, and reminded everyone that justice doesn't require permission. The battle for voting rights continues, but thanks to Jasmine Crockett's courage in that Dallas courtroom, it continues with the knowledge that constitutional principles can still triumph over personal prejudice. When someone is brave enough to defend them, hit that subscribe button and ring the notification bell. Because stories like this remind us why we need fearless advocates fighting for our rights every single day. Who do you think will be the next to stand up to judicial bullying? Let us know in the comments below. And don't forget to share this story with anyone who needs to see what real constitutional advocacy looks like. Because in America, the fight for justice never ends. It just finds new heroes willing to carry it forward. Thanks for watching and see you in the next video.